Wisconsin Attorney General J.B. Van Hollen is troubled by what the Healthcare Reform Act would mean to private citizens.
It's our strong opinion that the mandate for individuals to purchase health insurance that's contained within this new federal healthcare law is an unprecedented overreaching by the federal government. It is the first time that we've seen that it has been required that an individual, just by virtue of existing, has to buy something under law.
Van Hollen wants to join attorneys general from more than a dozen other states challenging the constitutionality of the new law. However, before he can do that, Wisconsin law requires he gets permission from the governor or one chamber of the state legislature. On Thursday morning, he formally asked for that permission.
As the Attorney General for the state of Wisconsin, I think it's very important that we represent the state's issues and the state's position. As Attorney General over the course of the last 3 years, a priority of ours has been fighting federal preemption, making sure that the federal government doesn't overreach its powers and authorities and usurp powers that should be reserved to a more local unit of government, in this case, the state of Wisconsin.
Van Hollen is afraid what it would mean if the Supreme Court upholds the Healthcare Reform Act.
It's our firm belief that if that is found to be constitutional, basically, contrary to what the United States Supreme Court has held in the past, they will have found that the Commerce Clause gives almost unlimited power to the federal government. That wasn't the intention of our founding fathers. It's incumbent upon us as states to fight to preserve the powers that were retained by us in the 10th Amendment to the Constitution.
Unfortunately, a law concerning healthcare reform could be a tough battle to fight, and that could have a big impact on whether Van Hollen gets the go-ahead to pursue litigation.
Unfortunately, because this new reach of the federal government comes in the form of a health care bill, I think there are people who aren't going to support my ability to litigate this because they're going to fear that it comes off as being opposed to health care reform. That certainly, I think, is a risk that we take. However, if we can get legislators and the governor to focus on the real issue here in this potential litigation, not being health care, but the real issue being states' rights and the overreaching of the federal government, that we should be able to get the approval.
Whether or not Wisconsin joins other states in challenging the new law, Van Hollen is confident the Supreme Court will eventually hear the case.
We've been able to see very recently what has been filed by other states. Obviously, we haven't been permitted to join them, so we're not part and parcel of their decision as to what issues they're going to litigate on and how they're going to litigate. The people of the state of Wisconsin elected me to serve as their top law enforcement officer and as their Attorney General. They didn't elect the Attorney General of Virginia or Florida, however competent those individuals may be. And I think that if we are fighting to preserve the rights of the citizens of Wisconsin and the Wisconsin legislature, that their attorney, the Department of Justice in Wisconsin, should be able to lead this fight. We can't rely on attorneys general who are elected to represent the interests of people in other states to necessarily represent what we think are the interests of the people in this state.
For the MacIver Institute, I'm Bill Osmolsky.